is actually the most interesting thing I've heard, I think, all month.
Apparently, somewhere in Texas, somebody got sued for it.
You're probably going to get a better deal, even paying a real estate commission and putting it on the market. And it doesn't have to take a long time.
They are going to lowball you as much as they can so that they make the most profit. And that's not a good situation to be in.
Hello, and welcome to the Texas Probate Real Estate Podcast. My name is Jeremy Critt, and I'm the owner and broker of Critt Real Estate and the founder of Texas Probate Real Estate. Today on our podcast, we have a very special guest, Teresa Shapiro, who is an attorney at law and specializes in probate, wills, and trusts. And she's going to share with us some wisdom and information that our audience can use to help them on their journey through the very difficult process of dealing with probate. As you may already know, I help probate executors and administrators all across Texas, but mainly in Central Texas, with selling real estate that is going through probate. So I just want to welcome our guest, Teresa Shapiro. Welcome to the show.
Thanks. Glad to be here.
Awesome. Teresa, I'm so excited to have you here. Actually, Teresa and I have a little connection in that we go to the same church. So I always see her advertisement in the bulletin. So it's so great to have you on here because I see you all the time in those advertisements. Teresa, if you could just do me a favor and help us kind of understand how you got into law and the area of law that you practice and how you got there.
Okay. It's kind of a convoluted story. I didn't start out to be a lawyer. I went to, my undergraduate college degree is neurobiology. I had intentions to be a doctor. By the time I finished, decided I wanted to be a mom instead of a neurosurgeon, which is a 24-hour-a-day job. And I wanted to be able to be home with my kids. So I stayed home and raised kids for 12 years. And then when they were in middle school or so, my marriage was coming apart. So I decided I needed to do something to be able to support my children. And I went to law school. It was just by the recommendation of, a whole lot of friends said, hey, I think you should go to law school. And it wasn't what I wanted to do, but I went. I went to Utah. When I got out, I had kids. I was a single mom by then, and there was no way I could go to work for a traditional law firm and work 90-hour weeks for them and still be home with my kids. So I hung out my Sheagle, and this was the thing that probate, wills, and stuff was what really interested me when I was going to law school. I loved the professor, and I really was fascinated by the process. And that's what I've done ever since for 25 years.
That's amazing. That's amazing. How does your practice intersect with probate? Since the majority of our audience are going to be executors and administrators.
Right.
Like, how did you get into that space, and what are you doing in that space currently?
Well, I do probate. I also do wills and trusts and powers of attorney. I don't write a lot of trusts. I can tell you about that later, but I write them. I just don't prefer them. So I do wills and I do trusts and so when I do them for people, I meet their families generally, at least some members of their families in that process, because usually an older couple will come, they'll bring their closest child with them so that they're in on the conversation and they know what the parents' objectives were, and they also want to meet me to make sure I'm a legitimate and reasonable attorney. And so once I have that established relationship, they come back to me to do probate when the time comes to probate that will, because a will has no effect until it's probated. It's just a piece of paper. And so it has to go through the court process of being accepted into probate. And then the executor gets letters of testamentary that give them the legal authority to settle the estate.
Teresa, I'm curious because you've practiced law for a long period of time, and I really love speaking with attorneys that have been doing it for a while because it's not your first rodeo. You've seen a lot of different situations transpire. I'm just thinking of some of my clients. A lot of times when I come in contact with my future clients, they're actually going through the process. They've already filed and they're kind of already, in motion. I want to go before that point, before the filing. And because I think that, this podcast, we have people listening to it where they might be looking for an attorney. Someone may have just passed away. They're not quite sure where to start. I always kind of say they don't teach in high school or college, what happens when someone passes away and how to handle it. I missed that class if they offer it.
So when someone dies, I get calls a lot. My mom died yesterday. What do I do? Take some time to grieve. Let yourself be emotional. Because when I'm faced with that kind of grief, when my father died when I was 12, when my mother died when I was in my when both of my husbands died, my tendency is to jump into business mode. Get rational, keep this thing together. I've got to do this, and I've got to do that, I've got to do this, and I've got a checklist I have to do. The thing is you're going to hit a wall if you do that, because you're running from the grief. You're trying to busy yourself with all of the things that have to be done. You have 4 years to probate a will from after someone dies. I don't suggest you wait 4 years, but I do suggest you wait at least a couple of weeks or maybe a month. Take the time you need to do a little grieving. One, it'll make going through the process so much easier for you because that initial emotional stuff will be over. Doesn't mean you're not going to stand up in court when you're probating the will and you have to answer these questions that you're not going to tear up. It's okay. It happens all the time. The judge is very compassionate. But it does mean that you'll have the wherewithal and the mental capacity, not from being incompetent as far as being crazy or demented, but the emotional capacity that takes will be less. And so you'll be able to think straighter and walk through the process of probate a little better. So I generally tell them, call me back in a month.
Okay.
And through it. And so we meet, we talk about, they bring me a copy of the original will. I have to have the original will. They can't keep it. And I need a death certificate. It also takes a couple of weeks, usually at least, to get the death certificate. So that's another reason not to deal with it the next day. And then they come in, I fill out a form with them of the information I need to probate the will that I need to do the application. We talk about if there's any issues with relatives. Sometimes siblings don't get along, and there's a child out there that's named in the will that the parents haven't seen in 20 years, but they're still named in the will. So you still have to track them down and give them their share of the estate. There's sometimes some resentment about that, but unfortunately, that's what happens in families. So if the will says they get money, they get money. You're limited in what you can do. You cannot take anything out of the house or out of the estate until it's probated. You have no legal authority to do that. So you walk in and you think, oh, well, mom said I could have this, I'm going to take it now. And you don't have the legal authority to do that. And as long as you're, if you do it, but you risk that your siblings or other beneficiaries of that estate are going to sue you for it. So, and if you've got a situation where there's animosity and that's why you're taking it to protect it, you're leaving yourself open to being removed as the executor and having the next person in line and having charges filed against you. For fraud. So you don't want to do that. So these tricky little things, they think it's stupid. Dad died 5 years ago. Mom died yesterday. I'm going to go get these things I want that mom said I could have. No, you have to wait. I'm sorry. You also need to then also go in and try to find bank account information and credit card information and investment information and try to start collecting the assets and figuring out what's there and what needs to be done. And that's a very long process sometimes. It depends on how well the person kept records. My kids, I honestly, I keep horrible records, but I don't have a lot to keep records of. So it's a trade-off. If I had a lot of stuff, I'd keep it in a book for them. And, this is this account, and this account, and this is how you get into it, Although I tell people don't ever put your password and your PIN number on the same place for your kids. Put them somewhere else. In case somebody breaks in your house, you don't want to just give them the keys to the kingdom.
Right.
But you should write all that stuff down. I mean, that's the biggest thing. In my estate planning packages, there's a section of documents at the back that are just informational purposes only, that have personal information about military past and all these things that you're going to need to know when you're doing something for someone. If your dad was in the military when he was younger and he needs to apply for Medicaid, the first thing they're going to ask is, was he a veteran? Because he might qualify for veterans benefits as opposed to getting Medicaid. So they need to know that information, that medical stuff, who you want notified when you're sick, your financial stuff, your household stuff, all this stuff is there so that when you get incapacitated, your kids can come in and take care of you. And that it's all right there in one place. They don't have to go hunt for it. When you die, all of the bank accounts are listed there, all of the investments, everything's right there for them to be able to know what's what.
Teresa, sorry, I want to go back for a moment and I want to explore something with you that I haven't actually talked about with someone on the show.
Okay.
So I want to go backwards in time, and you mentioned that there's four years to file that probate. So I want to explore that a little bit because one of the things that I find in my work in relationship to the sale of the property. And as you know, a lot of times in probate, really, not for everyone, but at least in my experience, I mean, my limited experience, which is, I mean, it's a lot of different sales, but usually I find that, there's a lot going on. There's a lot of usually sentimental attachment. Maybe it was
Yep.
mom's house. It's a house I lived in, I grew up in. There's a lot of
Mhm.
things going on. And there's kind of procrastination to sell sometimes. And the procrastination to sell, and it's not that the procrastination to sell in itself is necessarily objectively not a good thing, because it depends. But I've had multiple situations where, because the administrator or executor didn't move faster, it led into financial problems. There's holding costs to the property. If there's a mortgage, that's additional holding costs, taxes, et cetera. And one of the interesting things is, just recently, at least in Central Texas, we've experienced a really significant decrease in property values since May of 2022. And there was actually a point in time where we were going down like 1.5, 2% per month, which
Yeah.
is, in real estate terms, is
Huge.
very dramatic, very dramatic. It's almost, I mean, I could tell you for myself, I've been practicing real estate almost 9 years, and it really felt like the rug was being pulled out from under me in terms of just trying to understand value. Even that was difficult for a while. Luckily, it's stabilized a little bit now. But what I'm getting at is that one of the things I was telling my potential clients was, and not to push them to do something, because they have to go on their own timeline. But I was like, okay, you're kind of done with all these things. You just have the house now, and you've got maybe 3 other people that are kind of waiting for the
Yep.
proceeds of this property. And this value is going down, and it's going down quickly. It's not going down quite the same way as it was before, but it kind of put me in touch with, that aspect of like, okay, it's like, yes, you can wait, but there's a significant cost in waiting, and trying to have that conversation with them respectfully is like, yeah, I mean, you can do whatever you want to do, and, I'm here to help you, but just know that, this is going to cost significant money.
An executor has a fiduciary responsibility to preserve the wealth or the of the estate, and not to dawdle too long and have it depreciate,
Mhm.
or have it get in a situation. I just recently went through a multi-year lawsuit with a
Oh.
bank over mom had died. They didn't probate her will, but they didn't pay the mortgage.
Mm-hmm.
And the
Mm-hmm.
bank was trying to foreclose on the mortgage, but they couldn't because mom's dead. So it was this horrible long thing, and trying to track down this. There was 3 sisters. They didn't speak to each other. They were scattered across the country. It was a nightmare. It literally took us several years, and the bank won, and they forced sale of the house, and then the bank took the mortgage and the legal fees, and they only got what was left over,
Yeah. Yeah.
which
Yeah.
was a big house. So it pretty much was eaten up in legal stuff.
Yeah. Yeah, I totally hear that, because I've had multiple clients that are kind of going through something. I mean, not quite that far, but going
Yeah.
through things like that.
The other thing that
Mm.
happens a lot, I was thought you might be headed to talk about, was
Yeah.
dad dies. Mom thinks because they're married in Texas, it's community property. So when dad dies, it's automatically hers. And then mom dies 5 years later. Okay, well, it's been more than 4 years since dad died. Dad's will didn't get probated, but it has to be probated,
Mhm.
because you have to probate it in order for her to get the money. It's not just a transfer. It has to go through the probate process for those community property funds, because mom has the right to her community property. She doesn't have the right to his community property. And she's lucky in cases, because sometimes when banks find out dad died, they freeze community property accounts until mom can prove she has a right to those accounts, which she has to go probate dad's will to get. There's that issue. But in this case, mom's died now. The kids are stuck with a house that still has dad's name on it, who died more than 4 years ago, and mom's who's died now. So what they have to do is they have to probate dad's will for muniment of title, which is just to clear the title. But they have to do that first to get it into mom's name, and then they have to probate mom's will to get it to them. And so it's a 2-step process. It takes a lot longer, because you have to wait for dad's to get done before you can do mom's. You can't do them simultaneously.
Yeah.
So it's money that they have to come up with then, instead of having it be before. And there's some complications about whether you can even do muniment of title at that point, which
Mm.
means you've got a cloud on the title.
Right. You know, it's very interesting, this point that you bring up. I think this is one of the most misunderstood things in Texas.
Yeah. The way community property doesn't work the way people think it does. And
Yeah.
when I became a lawyer, I was startled to find that out myself. So
Yeah.
yeah, trying to explain it to people is very difficult. But I've had several people call me and say, what do I do? My mom's bank accounts are frozen.
Yeah. Yeah.
Probate your dad's will.
I've seen it as a real estate broker in that they want to sell the property, and it's like, okay, hold on here. We have some unfinished business here, you know. And if you practice real estate long enough, you come across these situations because it's just people don't know about it. It's so important, but no one teaches you. You know, there's no class on it. You know.
Some things you can do in that situation too is to do an affidavit of heirship, but it depends on the title company whether they'll take it or not. A lot of people don't like to take them.
So it's so funny that you mentioned that because I just had another podcast guest with another attorney, and she was telling me that in the area that she's working, which is a little bit more north of us in Bell County, that a lot of title companies have, sometimes the title company will help you do the affidavit of heirship. And she's telling me that at least in her area, because I think there may have been a title claim at some point with one of these affidavits, maybe they left someone out or something.
Mm-hmm.
And so a lot of title companies up there, according to her, and I believe her because she's really in the space, she's like, they're not even doing them anymore because it's just become too risky.
Not even here. To tell you the truth, I've done in 25 years, I think I've maybe done 10.
Yeah. Yeah.
It's not done a lot, and it really depends on the title company. It really does. And then when you go to resell it, it depends on the title company when you sell it, and some of them won't accept it. And I've had to do that where they had an affidavit of heirship.
The buyer bought it from the seller who did affidavits of heirship.
Mm-hmm.
Oh, that's interesting. I have not seen that. Tell me about that.
So the second sale, when they sold that house, the buyer's title company wouldn't accept the affidavit and heirship with the original estate.
Okay.
We had to go back and do a muniment of title then.
Wow.
To get it cleared on that family, track them down and get it cleared. I generally tell people just go to a different title company, but they were far enough along in the process they didn't want to do that.
So in other words, on the first sale, the seller, I'm just kind of explaining a little bit for our podcast. In the first sale, we had a seller who did affidavits of heirship, and that cleared, that basically cleared the chain of title and lifted any cloud on title that there may have been. And now the buyer is living in the house. They want to sell the property. And now they're doing the title search on the property, and they're going, hey, wait a minute, the last sale, this last link in this chain of title has this affidavits of heirship. This is risky. We're not comfortable in putting a title policy on it, right? That's what you're telling me. That had never come across that, actually.
Yeah.
That's very interesting.
I've never had that one time, so it was crazy. But I get really frustrated with companies because they try to practice law without a license a lot.
Right. Let me ask you a legal opinion on this because it's kind of interesting. So let's say you're the buyer buying the house and the seller's doing affidavits of heirship. Now, I would say in my experience of all the transactions I've done, and I've had a lot of transactions that involve affidavits of heirship, whether on the buy side or the sell side, I've seen it quite a lot. What you're kind of saying is that there's actually a potential risk when you're a buyer buying a house that has used affidavits of heirship. That's basically what you're telling me. Is that correct?
There's a small risk because, as I said, I've only had it happen once in 25 years. So I wouldn't dissuade people. I prefer to use an affidavit of heirship rather than do the muniment of title because it's cheaper and quicker. We just get the affidavit done and then we probate that second will and we're done. But now I've discovered, a very small risk that the next title company might not take it. I mean,
that's very interesting.
Let's say change title companies first and let's go with that. See because most of them will take it. But, you just have to, sometimes that's the easiest solution. Anytime you do anything that's not the normal progression of a will with letters of testamentary and probate, there's a risk.
Right.
Right. The title, whether it's a heirship affidavit, there's a small risk.
Yeah, that's very interesting.
When somebody sells a house under a power of attorney, there's still a small risk. The last house I sold, I rent now, but I used to own a house, and when my husband got sick, we sold it. He was in the hospital and very ill when I signed all the documents, and I signed him under his power of attorney. Well, there's a slight risk that down the road, somebody's going to say, well, how do we know that her husband knew she was selling this? Well, of course, my husband's dead now and been dead for 5 years.
Mm.
It's kind of late for him to make a claim against it, so not a problem, but there's a slight risk. The title, when I went to closing, so I said, well, you need to get your husband to come in and sign this. I said, my husband is in the hospital dying. I don't think he's going to be signing this. That's why I have this form.
Yeah, right. Now, my understanding, just going back just a moment on the title insurance, this is very, very interesting and relevant to the podcast. If the title company, closed the deal, then basically they
accepted the responsibility.
They've taken on the risk, right? Which it would explain why some are now not doing it, right? They're like, well,
right. Now we think there might be a license,
right?
Because they're all getting a little more careful about taking them now. And so
very interesting.
Got sued. I don't know where the case was. I haven't looked it up. I don't really care.
Yeah.
But that's what happens when these things start happening. It's because somebody got sued because somebody made a mistake.
Yeah, absolutely.
Or tried to pull something. It might not have been a mistake. It might have been intentional that somebody left somebody off of an affidavit of heirship because they didn't them on an estranged child that's been gone for 20 years that nobody knew where was, and they can't get them to agree to the document, so they'll just leave their name off.
Right, and then you're counting on the witnesses as well, right? You're counting that they're legit and they're.
It's a neighborhood where the mom and dad moved in and they never met the kid, and they never mentioned to them that they have this estranged kid out there somewhere because they've just written them off. The witnesses may not even know the kid exists either.
Right.
So they're testifying to what they know. And it says that on the affidavit, to my knowledge.
Yeah.
They can't testify for anything they don't know, and they can't be held liable for what they don't know. But I've been their neighbor for 20 years, and these are the only kids I know. Okay, great. Well, yeah, but there's another one you didn't know about because they disowned them 25 years ago.
So I want to go back for a moment to the 4-year waiting period on the filing of the probate.
I'd like to make a caveat to that.
Oh, yeah, please.
Real quick.
Please. Yeah, absolutely.
If you do have a child you want to disown, do a will.
Okay.
And probate it. Say in the will that you want to disown them. You can do that. It's just fine. You are not legally forced to give a child you don't want to give money to money. But you need to do it in a will where it's written out and it's legal and it's clear that that's your intention. And then you can disown them and not disinherit them, and it's fine. But you have to do that will, and you have to probate that will.
Yeah. And
then it's fine. But if you try to do it another way, it's going to come back to bite you.
Teresa, as I think about it's funny, affidavits of heirship come up a lot in this podcast. It's kind of interesting. It's something that kind of comes up in a lot of different ways. One of the things that's interesting from a sales perspective, which is obviously very different from kind of what you're doing, but it intersects to get it kind of connects, is one of the reasons why I really don't like doing affidavit. I mean, of course, I'm here to help sell the house and be of service, but one of the reasons why I don't like it is because there's not like one core decision maker. And it's like we've got all these people that are involved, and like it could be a lot of people, and like everyone's got to sign, everyone's got to everyone really should sign the listing agreement. Everyone's got to, when that offer comes in, everyone's got to know what the offer is and they have to agree to it. So it's like it's a lot of.
There's no executor or administrator of the estate or under a power of attorney that can just sign it.
That's right.
They all have to participate. And
absolutely.
Mom doesn't want the kids to know what she's getting for the house because she doesn't want them coming after money.
Right. And I'm just thinking back, Teresa, to several transactions I've done where it's like, okay, I'm trying to get them all on the Zoom call. I have a situation that might be like this coming up. It's like, I got to get everyone on the Zoom call. And like, usually I find this is just practically speaking, usually there's like a dominant or like the patriarch of the family or matriarch, or like the daughter that was kind of like looked at as like the one that has their stuff together and we trust her. But sometimes there's cases where everyone just distrusts each other, but they just need to sell. And I'm just thinking of like two like extremes. I've had some where, it's like they've kind of like they haven't quote unquote appointed. We don't have an appointed person, but there's someone who everyone's just like, hey, John, we trust you. Just keep us in the loop. But I'm like, well, no. We still have to. They still need to hear what's going on. I want to make sure everyone's on board because also people can change. Like, this transaction could be going on, and they're like, well, hey, I don't agree with what you're doing with whatever, how you're selling it or whatever. There's a lot of areas where people can start
I
disagreeing.
had somebody that told me it's worth $100,000 more than you're telling us, and you're just trying to get rid of it, not
Yeah,
get money out of it. Which
exactly.
my neighbor told me. It's not
Right.
like they really know.
That's right. That's absolutely
You know,
right.
that her mother had lived in that neighborhood and she got $50,000 more than what you're at. Your house wasn't as nice as our house. Of course, it was 10 years ago when the market was screaming.
Right. You're living in my world, Teresa. You're speaking my language here. This is where it all comes together, right at this
Yep.
moment. This is my world right here.
Yep.
Absolutely, 100%. For me, like just as a real estate broker, I'm just like, yeah, I want there to be an executor or an administrator, but life's not perfect, and it's affidavits of heirship is kind of like it's a little bit muddy. Like it's not the ideal
Yep.
way to do it, but sometimes it's the only way to do it.
It's a quick fix.
Yeah. Yeah. And I believe, if I'm not mistaken, like minion of title, affidavits of heirship, are those things that are unique to Texas or certain states? As I've kind of talked to people around the country, it seems like Texas has some more expedited ways of doing this.
Yeah. I know that muniment of title is common in some states. There is no universal law in our country. There's not. There's, the ABA has pushed for years, the American Bar Association. Most people won't know what that is. That is the national organization of attorneys. And it's not mandatory. Not everybody belongs to it. I used to. I don't anymore because I didn't get out of it what the dues cost. So I quit.
Okay.
But they have pushed for a long time to get a universal code. And there are some areas of law where there is a universal code. The probate code is one of those. There is a universal probate code drafted by the ABA, mostly based on Texas law.
Interesting.
So, for us, it was great. It's like, yeah, go for it. Not every state practices that universal code. Last time I looked at it, it was 28 states. So if they practice the UPC, then the laws are going to be the same. Their practices are going to be the same. The process is going to be the same. It's great. If they don't, it's anybody's guess. So in Ohio for a very brief period of time. My husband got a job up there and it didn't work out. And we came home, but which I was very glad to do. Their law is not universal probate code, and it is very strange. And I didn't practice because I wasn't licensed to practice in Ohio, but I went and talked to an Ohio attorney up there to see if I could maybe work as a paralegal for him or something. And he's like, oh, no, he said, you don't know our law. It's a lot of difference. And he goes, besides, I don't hire people from Texas. And I said, why? And he goes, because they don't stay.
Okay. God bless Texas. God bless Texas.
I was there 4 months.
Okay.
I went to 5 feet of snow. When the snow melted, I came home.
That's interesting. Well,
Yeah.
we're glad you're back in Texas, Teresa.
Yeah, me too.
What do you think? That's very interesting. I didn't know that. This is why I love this show. I always learn something.
There's a universal consumer credit code. That's why, like all the stuff with the credit card companies and stuff in a lot of states is the same way that Texas handles it. Again, a lot of the universal codes were based on Texas codes. I mean, Texas and California codes they took from both of them, but they were primarily Texas. Texas has the trust code. So again, when they passed them and created them and states started adopting them, it was great because I already knew what the law was. When I have to do a deed for, like if I'm doing a ladybird deed or a transfer on death deed for someone who owns property out of state, they inherited a cabin on the lake in Wisconsin or something, I have to find out what is the code in that state in order and whether they honor. Not all states will accept a ladybird deed. The ladybird deed was uniquely Texas. It's named after Lady Bird Johnson. That should tell you that it's uniquely Texas. So, but it's been more widely accepted and become part of that universal code, but it's not necessarily accepted in every state. Again, the last time I checked on that or heard a report on it, I don't do the checking. People do it for conferences, but it was like 14 states took the Lady Bird deed. Everybody will take the Todd. Pretty much that I've dealt with, they'll do a Todd, which is the forms are not significantly different. The biggest advantage is the Todd lets you do secondary beneficiaries.
Okay. Teresa, I want to ask you a question. So you mentioned that the ABA's kind of proposed kind of code to kind of create some sort of standardization, which makes sense. That makes a lot of sense. What do you think? You mentioned that it's kind of based on the Texas way of doing things. What do we get right in this state on this matter?
Okay, let me give you California as an example of the probate and the difference. It's the most onerous that I'm aware of. Most of them, it's not tremendously different. There's just nuances and ways things are done, and they don't have some of the ability like affidavits of heirship or muniment of titles. You have to probate everything. But in California, they don't have an independent administration. It's a dependent administration only. So you get an attorney, you go to court, and the attorneys charge a percentage of the estate for doing probate. Like 10% of the estate goes to the attorney.
Wow. Wow.
Okay, so then you've got to probate, and you could take your will in, and then you have to, when you start to settle, like you want to pay a bill, you have to go to the court and get permission to write that check. So you have to get your attorney, you have to make an appearance in court, you have to file a motion, have it approved by the court, then you can go write that check for that bill. When you want to make a distribution, you have to go to the court and get permission to do it. You cannot do anything in an estate without court permission, specific court permission. So one, the courts are backlogged because every single decision that gets made in every single state is in court. So a court, and they've only got a limited number of probate courts. So, their dockets are going to be long. So it might take you 6 weeks to get in to get a permission to pay a bill. In addition, you're going to have to pay your attorney for every one of those things. So it's going to take a long time and be very expensive in California to do probate. That's why Suze Orsman in the 80s was like, everybody needs a trust. Everybody needs a trust. Well, yeah, in California, you need a trust. Not so in Texas. Texas probate's a 15-minute situation and you're done if your will's drafted properly. So, and even we can maybe motion it into an independent administration instead of a dependent administration if all the heirs agree. It used to be that Texas attorneys couldn't charge a percentage. I believe that law has changed, but I don't charge a percentage anyway. I charge a flat rate for everything I do. I don't have to keep track of my hours that way. I hate having to write down everything. And it's like, oh my gosh, I've been on the phone with this person for 20 minutes. I got to write this down. No, that's not my nature. So I just figured out over years how long it takes me to do it on average, and that's what I charge. And I don't charge for every phone call. I don't charge for every email, every text message. I don't do that.
Teresa, can I just say one thing on that, just real quick? I don't want to interrupt you, but I just want to say one thing that's very interesting on this one point that you just mentioned. I have had many clients where like things are a little bit tight, and the attorney is just like every little text message, every little call, and they're frozen. Have actually like I'm talking to them and I'm like, well, I can't help you with this. You're going to have to talk with your attorney because you need whatever. And they're like, Jeremy, it's so expensive. And it's interesting to see that because and the attorney is also like, and I'm not an attorney. I don't know, that's a whole business. That's a whole different business model. And I'm not in that world, so I don't know exactly how the attorneys think of it. But I do see it from the client side when I'm helping them sell a house, and maybe we come across a legal issue, and it's like, okay, you know what? You need to talk to your attorney now because I can't answer this question for you. And they're like, they don't want to do it. And they'll maybe not talk to their attorney when they really should. Like I've advised, I've had situations, Teresa, where I was like, I felt so uncomfortable. I sent them an email. I have advised you to speak to your attorney about whatever it was, just so that it was on the record, that, hey, look,
in case it blew up.
Yeah. But they're so paranoid with the attorney piece.
Time ago that people resent that, okay, I'm going to hit the button for the timer, and, we've been talking for 20 minutes. This is going to cost you this much money. And, oh, wait, I got to put this on this phone because I need to have it on record. I need to have it on the timer or that kind of stuff. And like I said, or me writing it down on a pad. And I spent half of my day filling out that timesheet. I worked for a law firm for 8 years. So I had to keep my time. Drove me nuts. So I just don't do it. And like I said, I've been doing this 25 years. I know how long it takes me to draft an estate plan. It takes me to do a standard probate. And I tell them, if something comes up and this blows up and it's a whole lot more time, I'm going to charge you more money. But I will tell you before I charge you more money. And I will calculate out how much time it's going to take, and it'll be another flat rate fee. And they much prefer that. They know what it's going to cost. They can budget for it. They can pay it, and they're comfortable with it. And so I don't have to charge them up a retainer that has to be put in a special account that if there's interest on, it has to go in a special savings account, and the interest on it goes to the state. And I have to bill against that account for everything that I bill against. Well, I don't want to do that. I don't keep IOLTA accounts. I earn what I get paid. I don't get paid the whole fee up front. I get paid half and half. And so it works out. I've never had anybody complain about it.
It's
You know,
it's so
easier
interesting
for me.
it's so interesting to hear about your fees too, because that's how we operate. That's how real estate agents and brokers operate. And sometimes with probate, there's more work involved, and so sometimes we have to look at like, okay, this is going to be a very big project. Maybe it will incur more expenses, or So in other words, for me, I'm just used to just, first of all, working for nothing until it's finally, I mean, I'm paid only on the result, right? I'm only paid on the final result when everyone's happy and everyone signs something. So that what you're explaining to me or telling me is like, yeah, that's my world. I get that.
I
And
do.
I'll be on the phone.
It's a win-win for me. I mean, my clients like it because it's straightforward and they know exactly what to expect.
Yeah.
And I don't have to keep track of every minute of my day. And, so it just makes it easier for me not to do that. And I decided this a long time ago that I just wasn't going to do that. I read the rules to find out what I could do to not have to do an IOLTA account, which is the account the retainers have to go in. And I bill them half of the time and all of the expenses up front. And then I get the rest of the time when we're done. So it's like, because I can't afford to out of pocket the expenses. And so they're
Yeah.
listed out separately, but half my time. And if it's somebody that's really struggling, I might take a little bit less on the front end and take the rest of it at the end when they can actually access the estate. It's kind of a case by case thing, but I don't do that real
Yeah.
often. I have compassion for my clients, especially if they're in a tough situation.
That's awesome. We're getting a little bit close to the end of our time together, and this has been amazing. We've actually, Teresa, we've covered ground we have not covered ground before on the podcast. So I want to thank you. That makes our time extremely valuable, at least for this podcast. So thank you so much. There are two things I want to talk about, and they're totally not related. Okay.
That's
I want to end with your view on trust. So we're going to end there because
okay.
you have a little bit, I would view it as, and by the way, I don't mean this in any negative way at all. I don't mean this, but you
No,
have
no, I
what I,
understand. I have a unique view of trust. Yes.
yeah, yeah, yeah. I would
Attorney.
even dare call it a little bit contrarian, just because, and I could be totally wrong, Teresa. I could be totally wrong on this, but I've been attorneys, like their whole business is trust, and so everything's a trust, right? So we'll get into. I want to save that because I want to end that. But before we get into that, I want to talk about something completely different. So I want to
Okay.
share with you, Teresa, something that I am confronting in my business. And I want to share with you kind of my perspective on it. And then I want to get your kind of feedback or reaction, or just speak to it. So Teresa, as someone that specializes in helping people sell real estate in probate, my DBA is Texas Probate Real Estate. Okay. Actually, the Texas Real Estate Commission actually allowed, I wasn't sure if they're going to let me use the name, but they let me use the name. So anyway, so yeah, I'm in the space, and so I come at it from a little bit of a different angle. And let me explain what I mean by that. So when the filing occurs, it's public, right? It's public, and I have, let's say, a research team that I have that look at that information. And I believe that I'm offering a good service to these people because they're going through a difficult time. If I without patting myself on the back too much, I'm a very competent real estate broker. As you probably know, a little over 75% of agents last year in this country did not sell a house. The average agent's only selling 2 or 3 houses. I'm way, way beyond those metrics. So I'm transacting frequently in the marketplace. I'm also a real estate broker. I own my own firm. So I'm coming at this a little bit different than just kind of like maybe your agent that who's your neighbor. And one of the things about probate real estate is that people get inundated. The minute that filing happens, investors from all around the world, and actually I've realized that a lot of attorneys do not know this. So as soon as that filing happens, they start getting letters from investors all over the place. And the investor, we have to be clear about the model, right? In order for them to buy the property, because their intention is in one case, it's to resell it, I have to buy it well below market value so that there's enough room for me to be able to rehab and then capture that after repair value spread. And that's a legit business model. And by the way, this is not to poo-poo on the real estate investors, because real estate investors actually play a very important role in our communities. A lot of houses that exist in our communities become restored and become livable again, and it's good for the general value of a community.
Yeah, where mom lived in the house for 20 years after dad died and she couldn't take care of it and the kids weren't
Yeah.
paying attention.
Yeah. So there is I don't like to say like investors are evil, but Here's the thing. The other thing about this is that there's wholesalers where they're just going in, they're contracting with the seller, and they're actually just selling the equitable interest in the contract, right? They're just selling the contract at a higher price and they're making the money on the spread. So they're not even the end buyer. Now, the average consumer is not very savvy with real estate. They may never have sold real estate. Maybe they've done it once or twice over, very large gaps of time. And so they don't even know about this wholesaler. So if someone's coming to them with an offer, they don't even realize like this is not the end buyer. In fact, they're going to actually make a contract with you and then they're going to look for a buyer. They may or may not find that buyer. You've wasted time with them trying to find a buyer that doesn't materialize. But more importantly, here's the thing I want to say about this is that the executor and administrator, they're getting all these messages from these investors. And the message goes something like this. And forgive me, Teresa, it's a little bit of a long setup, but I just want to kind of set it up for you.
Okay.
So it goes something like this. It's like, hey, look, you know what? We know you got this house. Again, I'm paraphrasing. I know you got this house. Probably needs a lot of work for maintenance. Look, I'll buy it from you completely as is, no questions asked, and you don't have to pay a real estate commission and blah, blah, blah. And they're, because they don't have any fiduciary duty to the seller, they don't need to tell them what they think it's worth. Versus like myself, I do have to give a CMA. I have to give something to them that shows like I could be wrong, but I have to substantiate kind of what I'm doing.
Right.
And the thing is that so they don't know and they're looking at it and it's funny because they go, oh, I don't have to pay a real estate commission, so I'm automatically saving money. Of course, if I have it, if they're buying it for 60% below market value, it doesn't even matter what that commission is, right? They're losing tens and tens of thousands of dollars. Well, what I'm getting at is that while it's true, this is my position on this. While it's true, if everyone agrees and understands what's going on and they want to sell it that way, that's up to them, right? That's their choice. What I like to
down and dirty, but it's done.
But it's done. Where I'm a little bit different, Teresa, is that in the overwhelming vast majority of cases, I can't say 100%, although I kind of feel like it's 100%, but I can't say it's 100%. Okay, so let's say 99%. Okay. I know because of my skill set, my strategies to sell property, which is not just necessarily just hope and pray. Like I have, very specific strategies to sell real estate that a lot of people may not be aware of or know about. And I know that I can sell almost any property in any condition very quickly for way more net than they could from an investor. My message to executors and administrators is hold on, don't sign anything yet. I want to talk with you. And by the way, on my website, Teresa, I have a schedule. And one of the scheduling, they can schedule with me to have a no obligation, no pressure. And I put this in there, Teresa. I say, even if you say, Jeremy, I love you, you are going to sell this house for me, we will not do it on that call. We will schedule another call. I will go through my listing presentation. I'll make sure that we're in alignment and then we'll do it. So that call is truly like, we're not going to sign anything on that call. I try to remove all friction so they could talk with me freely and without any pressure. But I have another one that says, do you want to review your cash offer? I offer people to, if they have an offer from an investor, to talk with me. And I can look at that offer because, and I think you'll appreciate this as a lawyer, is, here in Texas, we have the promulgated forms, right? We have the Texas real estate contract, and the Texas real estate contract is a beautiful document. It's fair. It's fair to the seller. Well, maybe it's not quite as fair to the seller because the seller has a little less, once they sign that document, they're kind of locked and loaded for, there's a few little things, but it's a little bit more biocentric, but it's relatively fair. It's been, they're always updating it with, problems that come up, it's looked at a lot. And it provides predictability in our real estate transactions, which is very important, right? So we kind of know how.
We've been filling them out for years.
Yeah. So it's like there's predictability and we kind of know how the deal should go down. Now, a lot of the investors, they're going to use proprietary contracts. That's what I call it, proprietary contracts they've created. Or a lot of these investors, they've just gone to a seminar and they think they've become a real estate expert because they spent 4 hours and had a lunch paying $9.99, and now they think they know real estate, and they're using these contracts that are not from Texas. They don't follow things that are in the Texas property code and things like that. So all of this is to say is that what I like to tell people who I'm talking with or who communicate with me, they come to me directly, is, just because the house is in poor condition, okay? Just because your mom, your dad, your brother, your sister, your friend may have been a hoarder. And believe me, I have been in houses. I had a house in Circle C.
You wonder how in the world did anybody even live there? I mean,
Absolutely.
there's a 1-foot space to walk in through the house, and there's one chair to sit in. That's it.
Absolutely. I have one where I had to wear a hazmat suit to go in the property in Circle C. The house was actually restored and it was beautiful, but when I sold it, it was just absolutely a disaster, and it was I could hardly walk through the property. And so what I'm getting at is that no matter what the condition of the property is, it is very
Really,
like.
she was a hoarder with 17 cats.
Okay, yeah, there you go. Exactly. And 17 cats and hoarder goes together very, very, very nicely.
Mhm.
Absolutely. And I try to tell them, I go, look, you know what? No matter what the condition of this property, hoarders can still be very fast and it can be profitable. And that's what I try to tell the people I'm talking to, because sometimes they feel because I mean, I've sold houses that are very nice, that are luxury houses that are in probate, but like there is this class of houses, I will say, that are kind of not,
Problematic.
they're not pretty, and yeah. And they're like, oh, no, I don't think this could. Yeah, yeah, yeah. And they're like, oh, I don't think this could. And I'll tell you something interesting, Teresa. I'll tell you something interesting. A lot of real estate agents, they, in my opinion, in my personal opinion, First Amendment, okay, my opinion, because then I'll have the National Association of Realtors come to me, knocking on my door or something, is that a lot of agents also don't want to put it on the multiple listing service, or they don't want a public marketing because they're afraid of how the house looks on them. Like it doesn't fit my way of, like the kind of house I
Mhm.
want to be associated with. And
I
what
want
I'll
my
often see is
reputation to be that I show nice houses.
right, 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 right. And so I'll see some of these houses that might be in probate, maybe in our market here or other markets, and they're trying to do an off-market thing, right? And maybe they have their own little investor pool, which I don't do that. So I don't, of course, I have a lot of contacts in real estate. I could very easily make a couple phone calls and say, hey, look, I've got a deal for you. But that's not the right way to approach these sales because of the fiduciary duty, right? First of all, I
Mhm.
have the fiduciary duty to the client, right? That's one. And then the executor and administrator, they have a fiduciary duty to the estate and the heirs and all of that. And so that's why I think it's important. So this is all to say that that's why I think it's important that like something like the thing that I do, the type of real estate that I'm coming into contact with in these situations, this is where it's different when you're dealing with someone who sees it all the time and has strategies and approaches to sell houses like this so that it's maximally profitable, but also it's time sensitive as well. So what I want to do is just ask you, what do you what do you think about just that general situation in terms of like you got the investors, you've got, let's say you have someone coming to you, they're talking to you about this. Just what's your take, just generally?
I firmly believe in gut feel. If you're talking to somebody that doesn't feel comfortable, don't deal with them because there's a reason that you feel that way. Either they're an aggressive salesperson, and even though they may be very good, they're going to push you into something you might not want. And so, because their whole objective is to get their money out of it, they don't care necessarily what you get. So, gut feel. I also think it's better. You always want to get at least 2 or 3 especially in a difficult house, 2 or 3 opinions from different people. Investors are always only looking to make money. That's why they're investors. That's what it means. That's an investment for them. So obviously, I mean, and even if you think it's a hopeless house and nobody else is going to buy it, call around, get some opinions. I mean, it takes a little time, but it may well be worth it. It could mean $50,000-$60,000 worth of difference in how much money you get out of the house easily, maybe more than that. I personally don't like to deal with them. Tell them there's realtors out there that do great job with houses like this. I think I told you I had a friend who did it. She's unfortunately in Singapore now, but she got a high tech job paying her a 6-figure income that was too good to turn down. So
Yeah.
my loss. But she would go in and help people with this situation, and she would go through, she'd look at the house, she'd figure out what needed to be done. She would look at, what needed to be gotten rid of, and then what she could sell it for once that was accomplished. And she had a narrow profit margin that she was willing to accept, but it was a profit for her.
Mhm.
but it wasn't all of the money went to her and you got nothing.
Right, right, right.
You'd make an offer, and then she would go in and clean out the house, do the minimal amounts of repairs that were needed to get it on the market and get a fair price, and then she'd resell it and she'd keep the money. And people were happy with her. They felt like they got a good deal. And I have an idea that that's kind of what you do. And so it's like, you know, it's, yeah, they could do it themselves, but they also have to think about the time it takes and the expertise and all the different people they're going to have to contact to get
Yeah.
the carpet changed. Because if you've got a house with 17 cats, you not only have to change the carpet, you have to steam the concrete because cat pee gets in the concrete and then it'll still stink like cat pee even if you put new carpet in it. Those things cost money, and you have to find somebody that knows what they're doing, and you have to have, a list of contractors, and you don't need to do them.
And also, if I might add, and we could talk about this maybe sometime in the future, is that also sometimes selling it just as is with the right strategy can also be the most profitable way. And that's what I
It
try
is.
to.
It's something but see, that's where you come in, because I couldn't tell him that. I couldn't
Mhm.
tell him that this house you're going to make as much, if not more, selling it this way than you would if you do all the stuff and then do it.
Yeah.
So, it just depends on the house and the situation and what's wrong with it.
Okay, I now want to just go. I want to end now on. I'm going to call it the Teresa Shapiro Trust Expertise now, and this is this is the perfect place to kind of wrap up. Teresa has a. I don't know if it's unique, but she has a little bit of a different, from what I've heard at least, the layman here in
Mhm.
terms of legal stuff. I would say that a little bit of a different take on it. And so, Teresa, tell us a little bit about what a trust is first, and then your take on trust.
Okay. Trusts are a very complicated estate plan that is a contract with you and your heirs, and they don't sign it. You're dictating it, and people do them for a lot of reasons. My trusts, when I draft them, are about 70 pages, and that's kind of
Wow.
a minimum trust. And it's 70 pages of legalese, and people hate legalese. They don't understand it. They understand it when I'm sitting there and going through the pages with them and telling them what it says. But it's a way to to have control for multiple generations over how your money is transferred and how it's controlled. And people who do it, that's why they're called sometimes dynasty trusts. They want that control over everything for generations. I want my kids to get it, but my kids have to give it to this. And then when they die, it has to go to this person and they can only use it for this. It's that iron fist from the grave kind of thing, that they want to control everything that happens to that money until it's gone, however many generations that takes. It used to be that we did them a lot to avoid estate recovery for Medicaid. Well, Medicaid has changed the rules on that now. And you also had to have them done 5 years in advance. You had to pass that 5-year mark before they were exempt. But Medicaid now counts a house that's in a trust as an asset.
Okay.
So it doesn't exempt you from that. There's a lot of different ways that don't have to be complicated and are not 70 pages of legalese to avoid estate recovery from Medicaid. Very simple things we do that don't cost too much. I mean, I tell you what to do. That's all it costs, is the time it takes me to tell you. You do the rest of it, with the exception if you change the deed on your house. But I mentioned earlier a transfer on death deed or a ladybird deed. That's one of the mechanisms. It's a deed that's drafted to transfer ownership of your house on your death without having to do probate either. So you just take a death certificate to the county and they retitle the house because that's what the deed says to do. Okay, so trust, I've run into so many things, Suze Orsman sold them in the 70s and 80s as the end all and be all for avoiding probate. As I said, we can avoid probate now without having to do a trust. The only advantage to a trust, truly advantage to the trust, is the multi-generational control. And then if you've got a real complicated estate, yeah, or if you have a blended estate where you got remarried, your spouse has kids and wealth, and you have kids and wealth, and you want to enable for the two of you to be able to have access to the wealth as long as you're living, but when the second one of you dies, you want it to be divided back out according to how it was put in to the children of that parent. So, if wife puts in $1 million, husband puts in $2 million, when they both die, there's $1.5 million left. The husband's kids are going to get 2/3 of it, and the kids are going to get 1/3. So, but minus whatever was used by either spouse during their lifetime. But the problem is that typically the ways trusts are written, they become irrevocable and unchangeable after the first spouse dies. And it's done that way to protect the offspring of the deceased spouse from the surviving spouse getting remarried and giving all the money to another spouse. That's a noble effort, but during their lifetime, they can transfer it all to them anyway. I mean, it doesn't really stop that. I've had people do that. But you also have a situation where I had a situation, for instance, where a gentleman his wife died. His son moved into the house to take care of him. His son was a major beneficiary of the estate. He started abusing the dad and
Okay.
being mean to him. And his wife accused her of trying to have sex with her and all of this stuff. I mean, just horrible stuff was going on in his house. I mean, this is a very gentle, kind man. He did not do that. He loved his wife devotedly for many years. And so he made the son leave, and his daughter moved in and started taking care of him. Well, he wanted to change the will or the trust so that she could inherit the money. He can't do it. The son's going to get the share of the money because he'd exploited money while he was there. He was taking money from him. So he'd already taken his, and he wanted to protect his daughter. He can't do it. It can't be done. So, and that's the situations I run into with trust, and people don't understand them. They think they work the way a will does. Oh, I want to amend this. Well, you can't, and it's cumbersome. It's difficult. And like I said, you understand it when you're sitting in my office and I'm going over it with you. But when you're at home and you have something come up and you try to read that on your own, you're not going to understand it for the most part. I mean, 75% of the people I do them for wouldn't understand it without coming back and asking.
So I'm asked, Teresa, so if that's true, then they'll need more legal assistance to help interpret and properly execute it.
Right. And when the kids inherit it, when the second parent dies, then the kids have all these issues and don't understand it and don't know what to do. And it just creates this generational problem and generations of legal fees.
Wow.
So attorneys like them.
Right.
I don't. I'll forfeit all those fees. Thank you. I want my clients to be comfortable with what they're doing. And as I said, now there's so many ways that we can pass on death the house. We can transfer on death bank accounts, and investment accounts are beneficiary designated. So it all passes by virtue of law. You don't need a trust to do it anymore. It also means that you don't have to do probate when you do that if you set that all up the right way. And then you also can't have recovery from Medicaid because Medicaid can only come against a probate estate. If you don't have a probate estate, they can't come after it, but you don't need a trust to do that.
Right.
The only ways I favor trust, there's three things. If you have a complicated estate, you own businesses and rent houses and all of this stuff. Well, yeah, that's a very complicated estate to try to do all the transferring and stuff. Then you need a trust. If you have a blended family and you want to protect that, then do that. It's a way to do it and that. And also if you have an estate that might be subject to estate planning, to estate tax. Right now, you would need an estate that was worth more than $34 million. So if you don't have a $34 million estate, you don't need to worry about estate tax. The other thing is if you own property in multiple states, if you have a piece of the farm in Kansas and you have a timeshare in Florida and you have another timeshare in Colorado, you need a trust because you have to do probate in every state that you have property in, and not all states probate's the same as Texas. So you don't want to get into a situation like California where you have a horrible onerous probate to go through.
Teresa, I have a question for you. Thank you for sharing that. That's fascinating. Do you think, it's kind of two questions here. So do you think that some firms or attorneys are unnecessarily creating trust? Like, in other words, like it's kind of like a mill. It's like it's like, okay, you need a trust kind of thing.
Say that. Yes, I do think there are trust mills. And we've talked with the group and for years, I won't name names or point fingers, but yes. There are firms that are trust mills because it costs a whole lot more to get a trust package done than it does to do a will package. Because you're right, 70. And while a lot of it's legalese, there's still a lot of individual drafting that has to be done on a trust, just like there is on a good will. If you run into somebody that's using strictly a document generation program, I encountered a firm one time that said they use a document program because they want everybody's will should be exactly the same. And I wanted to laugh. Nobody's will should be exactly the same.
Right.
Nobody.
Right.
Because nobody's estate is the same as anybody else's.
Right.
So, it's like, okay, you want the McDonald's of estate planning? Go to that person. If you want somebody that will actually draft you an estate plan tailored to you, go to an attorney a lot of attorneys use the document generation programs. There's nothing wrong with it if they then do the drafting on top of it. It gives some boilerplate.
It's a template.
It's a template. I have my own templates. So, I mean, I don't generate documents through a program that somebody else wrote. I have my templates that I've revised over 25 years of work. And so I just paste in my own documents. But, we all have to do that because otherwise we'd be spending hours writing the same stuff in every will that
Of
a
course.
new it doesn't work. And in a lot of cases, some of the forms are statutorily dictated. So there's the basic statutory rules that have to be met and the statutory form, powers of attorney, medical powers of attorney, advanced directives. But there's individualization that goes into all of them.
Yeah.
So it's not 100%. If it's done right, there's not 100% of generation or template in it.
Teresa, I think what you've highlighted is how important it is, and this is true in law, medicine, humble real estate, finding professionals that put the client first and listen to what the client needs and understands their unique situation. I really resonate a lot with what you're saying, Teresa, because just if I could just kind of connect it a little bit to kind of my work. When I'm not in just kind of more traditional real estate where it's, it's like a couple selling the house or, some guy selling the house, because they're moving jobs or something. When it's something like probate, it's like you try to understand, like, okay, what's important here? Is time a critical factor here? Who's involved? What are we trying to do? Listening first to try to tailor the service that you're going to offer. Like, okay, do we need to clear stuff out of here? How much money do we have to work with? All kinds of things. There's all kinds of things, but it starts with like really listening to the client, really putting them first and thinking about them. What do they need and what's going to be the solution that makes sense for them? Not the solution that's going to make them the most money, not the solution that's going to, make me work less. What's the solution that meets their specific need? That's what I'm hearing from you.
Mm-hmm. Yep.
Awesome.
I tell people, I said, when they argue with me about trust, and because they've been programmed for, trust.
Yeah.
And some people, I don't want to disparage anyone, but some people want to trust because they think rich people have trust, so that if they get a trust, people think they're rich.
Got it.
Okay, you want to waste that money just for ego? Go ahead.
Yeah.
And I mean, if a client comes to me and really wants a trust, I'll draft it for him. But I'm going to explain all this first, and then I'm going to say, do you still really want it? And because you don't need to pay me all the extra money to do a trust when I can accomplish what you want not doing a trust.
Absolutely.
But some people just want that control. Some people just have been programmed so much that that's what they're supposed to have, and that's what they've been told, and they'll go someplace else if I won't write it for them.
Yeah.
So I'll write it for them, but I'm going to do what my clients want. But I want to make sure that they understand that it's maybe not the best option for them.
Yeah. Teresa, I think we have covered a lot of ground, and I want to really thank you for coming on the Texas Probate Real Estate Podcast. Sorry?
I said it's been fun.
Yeah. I had a lot of fun. I had fun because it was you specifically, and I'm glad that because for our listeners, viewers, whoever sees this out there, we go to the same church. So I actually saw her. I've seen you around. I just didn't know who you were. So now I know who you are. So I'll say hi when I see you.
The ad, they don't place the ad with me, so
Right.
They don't wear name tags, so nobody knows that that's me.
Yeah. And I want to thank you. You really shared some really nice insights that were different from other guests that I've had on here. So I want to thank you very much, Teresa. Before we go, I always I want to give an opportunity for you to share how people can get in touch with you, why someone might want to contact you if they're watching this.
Okay. Well, certainly I do estate planning, obviously. I also do probate. I also do guardianship, and I will help people prepare to apply for Medicaid. I don't do applications. I used to, but it just takes too much time. And it's just too much law that I have to keep up with on a minute-by-minute basis because it's moving parts all the time, and I just don't have the time. I'm a solo. I don't have a staff. I do everything myself. So I have one phone, and you can call me on my phone. It's 512-964-7872. I have an email is my name, Teresa, without an H, at tshapirolaw.com. tshapirolaw.com is my website. You can send me a note through there. That's how you can contact me. I'd be happy to help you with any of those things. I also help people get businesses. And if you've got a bunch of rent houses and you don't have them in an LLC, you need to come see me.
That will be a topic of another podcast. We can get you onto that one on that. That's a very good topic. Teresa, thank you again so much for
Well, you're very
spending.
welcome.
I appreciate so much. I know you're very busy and you got a lot of things going on. So thank you for sharing your expertise and your time with us. Thank you for joining us on the Texas Probate Real Estate Podcast. And if you want to know anything about our guests, we'll have it in the show notes below. Thank you very much.
Thank you. Bye-bye.